Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Attempted murder lawyer, Chicago, Illinois. Facing an attempted murder charge in Chicago, Illinois is a life-altering situation with extremely high stakes. Cook County prosecutors pursue convictions in attempted murder cases aggressively, and being found guilty can carry decades in prison. If you or a loved one has been accused, it's critical to have an experienced Chicago attempted murder lawyer who understands how to challenge the prosecution's evidence, protect your rights, and build a strong defense from day one. At Combs Waterkotte, we defend individuals charged with serious violent crimes throughout Chicago and across Illinois. Attempted murder cases typically hinge on complex issues like intent, witness credibility, and forensic evidence, areas where a skilled defense attorney can make a decisive difference. Whether negotiating for reduced charges or fighting for you at trial, our team is committed to pursuing the best possible outcome in your attempted murder case. Attempted murder lawyer in Chicago, serving all of Cook County, Illinois. When you're facing an attempted murder charge, the choice of defense attorney can shape the entire trajectory of your case. At Combs Waterkotte, our Chicago criminal defense lawyers bring a strategic, trial-focused approach to every client we represent in Cook County. We understand how prosecutors develop these serious charges and, more importantly, how to identify weaknesses in their case early and use them to your advantage. Our attorneys dig deeply into every detail of your attempted murder charge, from police reports and forensic evidence to surveillance footage and expert analysis. By building a comprehensive defense strategy, we position our clients to challenge the prosecution at every stage, whether through pretrial motions, negotiations, or in front of a jury. We know how overwhelming it can be to navigate the Illinois criminal justice system, especially when facing such serious allegations. That's why we prioritize clear communication, keeping you informed and involved while aggressively advocating on your behalf. Whether your case can be resolved through a reduction in charges or requires a full trial defense, our firm is prepared to fight for the best possible outcome. With a reputation for dedicated advocacy and a commitment to protecting our clients' futures, Combs Waterkotte stands ready to defend you when it matters most. Call 312-500-HELP to get started today. Attempted murder definition in Chicago, Illinois. Under Illinois criminal law, attempted murder falls under the state's general attempt statute. This law, 720 ILCS 5/8-4, covers instances in which individuals try to attempt a variety of crimes, including murder. Under it, someone commits attempted murder in Chicago when they act with specific intent to commit murder and takes a substantial step toward committing murder. The attempt law, when paired with Illinois' first-degree murder law, constitutes attempted murder. The first-degree murder statute, 720 ILCS 5/9-1, outlines three possible criminal elements that define first-degree murder. These include causing someone's death while intending to kill them or do great bodily harm to them, causing someone's death while knowing that their actions are likely to cause death or great bodily harm, causing someone's death while committing a forcible felony. Put plainly, in order to charge someone in Chicago with attempted murder, Cook County prosecutors must be able to prove that someone had an intent to kill a specific individual, took a substantial step toward actually killing that person, Chicago residents cannot be convicted of attempted murder for mere reckless conduct or the intent to cause great bodily harm. Premeditation to take someone's life must be proven. Some examples of the substantial step requirement for attempted murder include firing a gun at someone, stabbing someone in a vital area, lying in wait for a victim with a weapon, soliciting a murder for hire. Attempted murder sentence in Chicago, Illinois. When considering sentencing for inchoate offenses, Illinois' attempt law generally uses the one-step-down approach. In other words, if someone is convicted for attempting to commit a Class II felony offense, they'll be sentenced one step down under Class III felony sentencing guidelines. Attempted murder is the one exception to this rule. Instead, the attempt statute outlines specific penalties for attempting first-degree murder. The offense is automatically charged as a Class X felony, the most serious felony charge under Illinois law. A Class X felony conviction comes with a possible prison sentence between 6 and 30 years. On top of that, certain sentencing enhancements are possible in Chicago attempted murder cases, as outlined in 730 ILCS 5/5-8-1. Targeting specific victim groups can result in harsh mandatory minimum sentences. An individual convicted of attempting to murder any of the following groups will receive a 20 to 80-year prison sentence: a police officer, a firefighter, an emergency management worker, an Illinois Department of Corrections employee, an emergency medical technician, EMT. Attempted murder in Chicago or Cook County is also subject to sentencing enhancements for the involvement of a firearm. These enhancements add additional years to someone's prison sentence on top of the prison term required by their Class X felony sentence. They include 15 additional years in prison for attempting murder while armed with a firearm, 20 additional years in prison for firing a gun at someone during a murder attempt, 25 additional years in prison for shooting and killing or injuring someone other than the intended victim during a murder attempt. What to do after a Chicago attempted murder arrest? Given the steep severity of an attempted murder charge in Chicago, it's essential to know, understand, and exercise your rights at all times if you're arrested. The criminal defense lawyers at Combs Waterkotte recommend that anyone arrested for attempted murder in the Cook County area take the following steps. Invoke your right to remain silent. Attempted murder charges in the Chicago area depend on proving an intent to kill, so anything you say to police can be used to establish that intent. Do not try to explain what happened or minimize your actions. Just stay silent. Speak only to tell officers you are invoking your right to remain silent and that you'd like an attorney. In Chicago cases, even vague or emotional statements can later be framed as evidence of intent, making early silence one of your single most important protections. Request an attorney experienced in violent felony defense. Attempted murder is one of the most aggressively prosecuted charges in Chicago, so you need a defense attorney who understands how Cook County prosecutors build these cases and how to challenge them effectively. Make sure to find a lawyer with experience handling attempted murder or serious violent felonies. Early legal representation ensures your rights are protected during questioning and helps begin building a defense strategy focused on intent, evidence, and possible defenses. Do not discuss the incident with alleged victims or witnesses. Contacting the alleged victim or witnesses can be disastrous and lead to additional charges, including witness intimidation or obstruction. In attempted murder cases, prosecutors closely monitor alleged offenders' communications, especially if there is a prior relationship between the parties involved. Even apologetic or clarifying messages can be used against you, so allow your attorney to handle all communication and investigation to avoid making statements that could strengthen the prosecution's case. Avoid posting or messaging about the incident online. Cook County prosecutors frequently use social media as evidence in attempted murder cases to show motive, intent, or state of mind. Posts, messages, or even indirect references can be taken out of context and introduced in court, so ensure you do not discuss the incident online or through text messages. Ask friends and family not to post about it either. Keeping a low digital profile helps prevent prosecutors from gathering additional evidence against you. Preserve any evidence that may support your defense. Attempted murder cases often have conflicting accounts of what happened, so surveillance footage, phone records, witness testimony, and other evidence can be critical. Your attorney may act quickly to secure evidence before it is lost or overwritten. You and your family can help by identifying potential witnesses or locations with cameras. Acting early can preserve information that supports defense strategies designed to keep you out of prison. Never consent to searches without a warrant. When you're charged with attempted murder in Chicago, CPD may seek access to your phone, home, vehicle, or property for evidence like weapons, messages, or location data. You have the right to refuse consent to searches if police don't have a warrant or probable cause to initiate a search. Evidence obtained unlawfully may be challenged and excluded. In attempted murder cases, digital and physical evidence can play a major role, so restricting police access to your property at this stage can significantly diminish the strength of the prosecution's case. Prepare for aggressive prosecution and court hearings. Attempted murder charges are treated extremely seriously in Cook County, and prosecutors often seek strict pretrial detention. Your first court appearances can shape the entire direction of your case. An attorney can advocate for your release, challenge the strength of the evidence, and begin negotiating if appropriate. Being prepared for these early stages helps you and your family make informed decisions about your legal defense. Attempted murder criminal defense strategies in Chicago, Illinois. As serious as attempted murder charges in Chicago are, building a good defense against them is still possible. At Combs Waterkotte, we've helped clients in Chicago homicide cases before, and we've found the criminal defense strategies below to be very effective at getting charges reduced or dismissed. Challenging the alleged intent to kill. Attempted murder in Chicago requires proof of a specific intent to kill, not just harm or scare. Defense attorneys often focus on showing the defendant lacked this intent, arguing the conduct was reckless, impulsive, or aimed at something less than causing death. In Chicago cases, prosecutors may rely on circumstantial evidence like statements or weapon use, which can be challenged. Undermining intent can lead to reduced charges like aggravated battery or reckless conduct. Challenging ballistics and forensic evidence. Chicago and Cook County, attempted murder prosecutions often rely heavily on forensic evidence, such as ballistics, gunshot residue, or DNA. Defense attorneys can scrutinize how this evidence was collected, tested, and interpreted. Errors in forensic analysis or gaps in the evidence's chain of custody can weaken the prosecution's claims. In Chicago cases involving firearms, challenging whether the defendant actually possessed or fired the weapon can be a key strategy. Self-defense or defense of others. If the defendant acted to protect themselves or another person from imminent harm, self-defense may apply. Illinois law allows reasonable force, even deadly force, in certain situations. In attempted murder cases, this defense focuses on whether the defendant reasonably believed force was necessary. Chicago attorneys often analyze surveillance footage, witness statements, and prior threats to support this claim and show the actions were justified under the circumstances. Mistaken identity and eyewitness misidentification. Attempted murder charges often rely on eyewitness identification, which can be unreliable, especially in high-stress situations like shootings. Defense attorneys may challenge lineups, photo arrays, or identification procedures used by Chicago police. Factors like poor lighting, distance, and racial biases can lead to errors. By exposing weaknesses in identification, the defense can create reasonable doubt about whether the defendant was the person who committed the alleged act. Alibi defense. An alibi can be a powerful defense in attempted murder cases. If the defendant was somewhere else when the incident occurred, that means it's impossible for them to be responsible. Chicago defense attorneys may use surveillance footage, phone location data, receipts, or witness testimony to establish the defendant's whereabouts. A well-supported alibi can directly contradict the prosecution's timeline and undermine the credibility of their entire case. Suppressing statements for Fifth Amendment violations. Statements made during CPD interrogations can be central to proving intent in attempted murder cases. If Chicago police failed to properly advise the defendant of their Miranda rights or used coercive tactics, those statements may be inadmissible under the Fifth Amendment. Defense attorneys often file motions to suppress such evidence. Removing a confession or damaging admission can significantly weaken the prosecution's ability to prove the mental state required for an attempted murder charge. Challenging illegal searches under the Fourth Amendment. Police may recover weapons, clothing, or digital evidence that prosecutors may try to use to build their case. If that evidence was obtained through an unlawful search or seizure, it may be excluded under the Fourth Amendment. Chicago defense attorneys examine whether officers had valid warrants or legal justification for their actions. Suppressing key evidence can limit the prosecution's ability to connect the defendant to the alleged crime. Negotiating reduced charges. Sometimes in an attempted murder case, the most effective strategy is to negotiate with Cook County prosecutors to reduce the charge to a lesser offense. This is especially likely when there are weaknesses in proving intent to kill or conflicting evidence. An experienced Chicago defense lawyer can leverage these issues during negotiations to pursue a plea deal that significantly reduces sentencing exposure and avoids the most severe penalties associated with attempted murder convictions. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.